Hey, everybody. Welcome to American Courts. Thank you all for coming out here. Gina, you were asking if I do YouTube full time. No, the video that you just saw was from a job I did today. I do a lot of 3D modeling with drones. I go out and take a lot of pictures. That one there was about 400 pictures, and we make a 3D model of the property, and they're able to determine how much material is in the piles and how much they need to order. I also do it for safety purposes for companies and for operational opportunities for companies. So, KK, I got your email today. I will respond back to it. I'm checking out some of your videos. I'm an old man. I had to learn Spotify a little bit better. It was hard to figure out. So, but I'll get there and I'll get you an answer back. Thank you so much for sending that to me. We got some interesting videos tonight. Is anyone following the Sarah Boone trial? I love the bigger trials. I love watching them, and the YSL trial in Atlanta. I'm following that one, and so I'm looking to see if any of y'all are interested in seeing any of those. I've got the opening statements on both sides of the Sarah Boone, and then in the YSL, one of the witnesses ended up getting arrested in court, so that was kind of interesting to me. And so it'll be neat to see where it goes. We're going to start off with Judge Rosie. I always loved Judge Rosie Gonzalez out of San Antonio, and so we're going to jump there.
Let's open the record in case number 573-322 in the United State of Texas versus Mr. Zepatrick Lee Carter. And this is set for a status conference. Can I get announcements from the attorneys and from probation, please?
Jordan Sims for the state of Texas.
John Fernandez for probation.
Marie Martinez for probation.
I can't hear any of y'all. Can y'all hear me?
Yes.
You know what? I know what's going on. You're right, Olga. Unmute and original.
That old globe.
Yes, the globe. Okay, so did you get them on the record, Olga? Okay, so we are set for a status conference today. Mr. Carter was found guilty by a jury of the offense he was charged with, which was an assault causing bodily injury to a family or household member, alleged to have taken place back in 2017. He was sentenced and then he appealed the jury verdict and the sentencing, and both of them were affirmed and sent back. It's taken quite a while for Mr. Carter to get on board and comply with his conditions. So today, before anybody puts on any evidence, I'm just going to say this now. You got two choices, Mr. Carter. You don't get to sit back and do nothing. So you can either sign the paperwork to go to DDRF, which a professional recommended, and I follow professional recommendations, or you can serve the remainder of your time at the Bexar County Jail. Which one do you want to do, Mr. Carter?
These are my only two choices, Your Honor?
Yes, and I don't have to give you choices. I can just order you either into DDRF or order you into the Bexar County Jail. So you're getting some grace from me today. Which one do you want?
I don't want to go to Bexar County Jail, Your Honor. So I would rather take the DDRF. Am I allowed to say anything else?
Nope.
Yes, ma'am.
You're not going to talk me out of it because I follow the professional's recommendation, and you don't know more than that professional. And from what I heard in that trial, sir, you need DDRF. So you may be in denial about all your behaviors and its effects on people. You may be in denial about your own trauma. You may be in denial about how you navigate in the world. You're going to go to DDRF. It's court ordered. He's got 24 hours to sign that order. If you don't sign your paperwork to go into DDRF by 5 o'clock tomorrow afternoon, I'm signing a warrant for your arrest. We're bringing you in, and you're going to serve the rest of your sentence, as I'm allowed under my discretion to sentence you at the Bexar County Jail. And the reason will be for your lack of cooperation with my court orders and probation recommendations. Do you understand that, Mr. Carter?
Yes, Your Honor.
Officer Martinez, what does he need to do next? He's got 24 hours to do it.
He needs to report to his probation officer and sign paperwork for DDRF. You also need to decide if he can do the medical on bond, or do you want him to do the medical in jail?
We'll give him a chance. Let's see if he does the medical on bond. If he doesn't cooperate, when does he have to do the medical?
Mr. Fernandez?
I'll need to email the nurse to get him that medical after the paperwork is signed, Judge.
What is the average time after paperwork is signed for the medical? What have you experienced?
It's usually about 2 weeks.
Okay. So tomorrow's the 16th, and you anticipate he'll be in for the medical before the 1st of November, Mr. Fernandez?
Yes, ma'am. I will ask the nurse for that.
Okay. So he has until November 1st to get his medical taken care of to go into DDRF. But tomorrow, he's got 24 hours to go and sign his paperwork. If he does not show up to sign his paperwork, if he comes up with any excuse for not coming in to sign his paperwork, I'm issuing a warrant, and he'll be taken into custody at the next contact with law enforcement. Yes, go ahead.
Is he allowed to sign his paperwork via Adobe Sign if that's an option with the officer?
If it's an option with the officer, absolutely.
Okay.
Judge,
Yes, sir.
there is actually a modification already that has DDRF held in abeyance.
Nope,
So-
we're not holding anything in abeyance.
No. The fact that it's already held in abeyance, he still needs to sign a new condition.
Yes.
No, he doesn't
Okay.
need to sign a new condition, Your Honor. He just needs to sign the program order.
There you go, Mr. Fernandez.
Okay.
I have to rely on the experts in my court. Officer Martinez is telling you what needs to get done next, so he has to sign the DDRF order.
And then he will need to wait in Bexar County Jail for transfer to DDRF. Do I need to send an SR with a directive for him to, like, a surrender date?
Okay.
Yes.
Get all that ready.
Okay.
Okay.
After medical, you can send over that SR with the surrender date.
And I'll send the program order with that.
Yes.
Okay.
And
So-
if your manager wants you to make a new condition, then you can do that. But I don't think we need it, but ask your manager.
Okay.
So just to be clear, if you don't cooperate, Mr. Carter, within 24 hours, I will issue a warrant. You will have an attorney present at the next hearing on that warrant. Okay? Today, it's just a warning. There's no adverse action taken against you. I'm warning you as to your non-compliance, and I'm entitled to do that. You don't want to comply, that's your choice. You got decisions to make. But you don't comply, then I'm issuing a warrant, and we'll take it from there. Yes, Officer Martinez.
And Your Honor, the reason for this is I just wanted to go on the record that since he has been placed on probation, he has never submitted a negative UA. He has either failed to submit on 2, 4, 6, 8, 9 times, and all the other 3 tests were all positive, with the most recent positive being October 9th, 2024. And he was in outpatient treatment, and he failed to attend, so he was exited, and that is why we are now starting the DDRF process, because he's been
that's
given
fine.
multiple opportunities.
Keep it up, Mr. Carter. Keep it up. You don't want to comply. Those are choices you make. Just know that your choices are going to land you serving time at the Bexar County Jail sooner than later. You don't want to go to the Bexar County Jail, then you need to start complying with your conditions of probation and orders from this court.
Yes, Your Honor.
Thank you, sir.
Oh.
Have a great afternoon. That concludes the hearing.
Hey, I just wanted to mention, I'm going to back it up 30 seconds, see if we can go there, find the lady in the top right corner. She has the wildest hairdo. I think she's the court clerk. She does great. She does great for her, but she's got just the wildest hair. I'm trying to get it to stop where it shows her hair. It always amazes me every time I watch this court, how her hair is. Yeah, there you go. Victoria, is that a thing in Texas? Is that what y'all do in Texas? I'm way too old for hairstyles like that, but she's got a neat hairdo there. Yeah, Bodie, the probation violation is the arrest I'm talking about in the court thing there. But this is the YSL trial is a mess. I really went into it. Not thinking that I was going to be on the defendant's side, but after watching that trial for so long, it's I had to give up on it. The state's doing so many dirty things in there. I just gave up on it. But it's a wild one. It looks like that one's got the interest tonight. So we're going to jump over that one. It's about a 30-minute video, but it's interesting to see how they play each other sometimes. And they ended up taking him out in handcuffs, and that was a kind of a dirty deal. Nobody wanted to be in that courtroom because of that, and so that's how it works out there. But we'll go ahead and look at that, and at 9 o'clock we're going to switch over to American Courts 2 and do that Court Addict again. Just stay here with the channel. It's gonna move you over there. It's a magic transition. It's just a YouTube magic. So let's go to YSL first.
State filed a notice of a probation revocation for the defendant. as to his violation of a special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for Your Honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant, if Your Honor wants to preview it or wants to be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the...
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that.
So,
Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
yes, and I'm very much aware of that. The transcript obviously is not ready as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew Your Honor
All right.
either could take judicial notice
Thank
or
you.
rewatch it. Can I approach it?
You may. And can you try to use a mic, please?
Yes, Your Honor.
Can I, they go to the court reporter.
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright,
Your Honor, may I remain seated or?
it's probably easy, you can. It's probably easier to hear you that way.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your Exhibit 6? I think I
Well,
only got 5.
Exhibit 6 is the one thing, and that's just a listing of my emails in December between myself
Oh, that's
and
this
Ms.
one
Love.
page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
that's fine.
So succinctly, I thought it best to submit these exhibits. When you look at Exhibits 1,
And
2,
those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at Exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of the cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, Defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits, or the 2 drafts, which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah,
Now-
and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see Defendants 3 and Defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was Defendant's Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office, I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here, I'm in person.
Right.
So we would get it, and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on Defendants 4, use this one.
But are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will
testified
take
to
judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So, ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that that statement was false. That is,
Yeah, I'm not sure about that. That may be your contention, but.
well, we would contend to the court that where my actual email defendants 2 clearly denoted that.
It does not. That is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So.
But your response on your Defendant's Exhibit 2 to what is then item number 4 does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood, understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after, what was that, December of 22, was now, for the first time, being drilled or asked questions, rather, as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw.
Hey, Victoria, I'll go ahead and answer some of that. YSL is a rap group in Atlanta, and so they got about, I think, 30 something of them on a RICO trial. They're trying to get them for murder and robbery and all kinds of money crimes, and so this is a guy here. They got him to testify, and then they're going to put him in jail for what he testified for, and because he admitted to committing some crime. So it's a mess.
Was probably frustration on his part at times, and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right. Anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right.
relates to.
You know what? I think I'm still on Zoom.
Yes, Judge.
Yeah. And what's the officer's name?
That's Jolly.
Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. I know. So that it's not a disembodied voice. Hang on. All right. Hello, Officer Jolly.
Hello, Judge.
All right. What is probation's? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky
The
of
DeKalb,
him, since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04SC23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated
I'm going to fast
situation that
forward
I have
some of the
regarding a revocation.
probation stuff.
On the
Get past
testimony
that.
and how.
What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked, is that right?
It's not the
Or
request.
is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number. That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it will please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation, and I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. he's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many reasons why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And he will be continued on probation, Your Honor?
And reinstate the balance.
Your
Thank
Honor,
you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
So they asked the guy to come in and testify.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
But they made him
Sorry.
testify, and then whenever he testified and lied, which is what he does, they ended up violating his probation, because when you get a immunity deal, you have to be honest. You have to tell the truth. And so he messed up, and he's there. So, but Kim, I don't know anyone that you offended, and I learned early on you gotta, everybody ends up getting offended. So but it'll be all right. Nobody holds on to grudges here. We're all positive here. We're going to jump over to Sarah Boone. We're going to look at the husband testifying. I've got the opening statements for both the state and the defense, but we're going to look at the husband testifying. It's a lot shorter and a lot more exciting. Got a lot more going on. But don't worry, Kim, you're great here with us, and I don't know anybody who's not welcome here. Everybody's on the team here.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you know the defendant?
I dated her for quite a while, and then we eventually got married.
When you say you dated her for quite a while, how long are we talking?
I met her in the late 90s, and I believe it was around 2005 when we got married.
Did you have any children as a result of your marriage with the defendant?
Yes, we had one son.
And how old is that son?
He is currently getting ready to turn 14.
Did your marriage with the defendant last?
No, it did not.
And approximately when was it that you separated and began proceedings for divorce?
Probably 2017, I'm thinking maybe.
And at that time, when was your divorce actually finalized?
Maybe it was 2016. I think the divorce was 2017, I believe.
And after your divorce, what was your custody arrangement with your son that you had in common with the defendant?
She was supposed to have him on Mondays and Tuesdays. I would have him Wednesday, Thursdays, and then we'd alternate Friday through Sundays every other week.
So 1 week you would have 5 days with your son, and another week she would have 5 days with him.
Correct.
And was this still the same custody arrangement in February of 2020?
Yes.
And in February of 2020, do you recall the events that occurred, I guess, first on the late evening of February 23rd, 2020?
On that evening?
Yes.
Well, apparently, Sarah called me at one point during the night.
Do you recall about what time she called you?
I think it was 11 something.
When you answered the phone, how did Sarah sound on the phone?
She sounded like she had been drinking and was pretty drunk.
Were you able to understand what the defendant was saying?
Somewhat, but she woke me up. I had work the next day. I was asleep when she called. She's done this before, calling me late at night, and generally I kind of just try to ignore it, so I wasn't really paying attention.
Who was she living with at the time?
George Torres.
When she called you late that evening, could you hear George in the background at all?
Not that I remember, no.
Did you pay much attention to this phone call?
No.
Now, the following morning, on February 24th, 2020, did you begin to call the defendant?
Yes, I did.
And approximately what time did you begin to call the defendant?
I think it was like 11 o'clock or something.
And why was it that you were calling her?
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was calling to try to find out if she was going to be actually picking him up that day.
Why would you have a question about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
So it was not uncommon for you to have to remind her to pick him up or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Do you remember at what time on February 24th you actually got in touch with the defendant?
I think it was like 12:30 or something.
And when you actually got in touch with her, what did she tell you on the phone?
That George was dead, and if I would come over.
Did she say what happened to him?
I don't remember if she told me then on the phone or when I got there, but she told me they had been playing hide and seek and that she fell asleep.
What did you advise her to do?
I told her she needed to call 911 and that I would come over as soon as I could.
And this is on your first phone call here at approximately 12:30.
Yes.
On 2/24/20.
Yes.
Did she call you again while you were en route to her residence?
She did. She called to find out if I was still going to be coming over.
And when you spoke with her while you were en route, what, if anything, did you advise her?
I told her she needed to call 911 and told her I was on my way, but she needed to get somebody over there.
How long did it take you to arrive at her residence?
From the first phone call, or?
Yes, from the first phone.
Well, I mean, I live a minute or two drive away, but I had to get my puppy. We had just gotten a puppy recently. I had to get him in his crate and stuff like that and put something on because I was working from home. And total time, maybe 10 minutes.
When you arrived at her apartment, tell us what she told you when you arrived.
George was dead, and I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep. But I, at that time, told her again she needed to get 911 called to get somebody over there.
Had she called 911 at this point?
No, she had not.
So you've advised her now 3 times to call 911.
Yes.
Did you go inside of her apartment?
I walked in the front door into the little tiled area, like entranceway thing.
What, if anything, did you observe when you made it to that point?
Looking into the living room, I could see like the end of his feet and maybe a little bit of some legs that were kind of coming out around the backside of the kitchen area.
Did you continue to go into the apartment?
No.
Where did you go?
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her. And I told her that I didn't really feel comfortable being inside. And I went out front and got in my car and waited for people to show up.
Did you witness the defendant call 911?
I think I was in there when she dialed it and first got somebody on the phone. But I wasn't there for the whole conversation, no. I was outside.
Did you stay there at the scene while police arrived?
Yes. I was there. I was part of it. I knew I'd have to talk to somebody, so.
Did you talk with law enforcement?
I did.
Your Honor, I have no further questions at this time.
Thank you. Any cross-examination?
Judge, we want to reserve our questions for when we call in our case.
Okay. All right, sir. You're subject to recall.
Okay.
Thank you.
Thank you.
Okay, so there's the craziness in that. Yes, she went through 8 attorneys. I think this is number 9. The other 8 they hit up the judge pretty hard trying to get paid for it, so they were able to get that solved. The last one I got for you tonight is a follow-up from last week. Last week we had a goofy guy in Boulder, Colorado, who was having to represent himself. He was arguing about getting water in a park, and he wanted to take it to trial. Well, I got the follow-up from that, and so we're going to jump over to that one, and then we're going to go over to court addicts. So let's go with that.
My thoughts on how we might approach this issue and to allow defense counsel and the prosecution to give any thought that they might have regarding the issue that's been presented. And I will frame it in this way, that when Mr. Mustafan appeared, he was frustrated, and correct me if I'm wrong, Mr. Mustafan, but I'll just try to summarize what I think you had said at the last court date, that you were frustrated with the representation from Ms. Talene and that you did not want her to represent you. Is that fair to say?
That is correct.
Is that still the case, sir?
No.
Okay, would you like to have a meeting with her right now? We can put you in a private breakout room area.
So, Your Honor, if I can jump in, I was
Sure.
already able to have a breakout room with Mr. Mustafan.
Okay.
And so I can sort of make a record about that. First of all, I will let the court know I did apologize to Mr. Mustafan. I kind of had a short fuse last week, not because of him or his case, because of some other sort of hearings that I had been dealing with on that same day. So I did apologize to Mr. Mustafan. He is going to continue with my representation. I know that he doesn't like phones, emails, texts, so we've already pre-set up a meeting at the courthouse to sit down and prepare for trial in his case. He still does want to go to trial. And I will let the court know that I did speak with him. I believe if I do call any witnesses other than what the prosecution is planning on calling, it will only be Mr. Mustafan himself.
Okay. Well, that's good information for me to hear. I always appreciate it when the parties and the council can resolve whatever conflicts are existent without court intervention. So that puts us in a much different posture than I thought we were going to be in, which I appreciate. Can you pull me up a jury readiness conference document? I think they might be over here, Catherine, to my left, right back here. There's a stack of, I think that's where they are. If not, you can ask Nick because he probably knows where they are. But I have pulled up the one from last week, so I can just go over that with people as well. So it'll guide me in my discussion. That's really what I use it for. We'll start with legal issues. I don't know that we have any legal issues that need to be addressed. I'll ask you, Ms. Tolina. Looks like you're shaking your head no.
Yes, that's correct. I don't believe we have any pre-trial legal issues to discuss.
Is that the same for you, Mr. Reynolds?
I don't have any issues that need to be brought up at this time, Your Honor.
Okay. And then I think you both counsel understand what voir dire will be about, usually about 20 to 30 minutes per side for voir dire. And for your purposes, Mr. Mustafan, that's the time, amount of time that's allotted for each attorney to talk to the potential jurors before they select a jury for your case. So just giving them each about 20 to 30 minutes to ask questions, that's exactly right, of those jurors. And then we probably have, so let me just take a quick look here, Mr. Reynolds. We may have already your disclosures. Yes, I have the city attorney's disclosures. And what you've identified here is just Mr. Clute, who would be a witness, and then any witness that's contained in discovery. But do you anticipate it's just going to be Mr. Clute, perhaps an officer as well?
Well, it would definitely be Officer Clute.
Okay.
And it's possible that the other officers who responded, one or more of them who are contained in the body-worn camera, could be a witness, but definitely Officer Clute. That's all that I would say in terms of my potential witnesses.
Okay, thank you for that. And then I don't see that there were any specific exhibits. I identified just perhaps pictures of signage at the location, maybe a diagram.
Of signage or like the Ranger Cottage, just so we could help the fact finder understand, about the location. But that's my that would be my exhibits.
And has that been shared with defense, those actual exhibits?
No.
I definitely got a list of them. I'm not sure about the actual exhibits. I'd have to look back, but yeah.
Yes, I have not sent her any pictures, but basically it would just be me going out and taking a picture of the Ranger Cottage.
All right, so at some point,
nothing surprising is outside of the realm of things like pictures of the area.
Okay.
Don't forget the picture of the water fountain, please.
Well,
and I can go take that picture too, Mr. Mustafan. Okay, so we have it.
It's amazing how you treat this case as if I killed the police officer.
We handle every case the same. We have to make sure that we go through the constitutional rights that people have and make sure those are protected. So I understand that you may not feel it's necessary, but for my purposes, I think we have to do it a certain way.
should go.
All right, I've looked at disclosure. I'm not seeing a specific disclosure, but you did make an oral disclosure that the only witness you anticipate possibly calling is the defendant, and that'll be, of course, up to you at trial.
Correct. Yes.
Mr.
And
Reynolds,
I did have a discussion with him about witnesses. So yeah.
all right, and Mr. Reynolds, do you have any need for any additional disclosures from the defense?
No, I don't. Just that if Ms. Deline identifies a different witness, then just at her earliest convenience, letting me know about that. Just like I will do.
Absolutely.
Sounds reasonable. I'm going to take a quick look at the rest of this document as well as our jury trial date, which I believe is November 14th for 6 jurors. So I would anticipate that 1 week before that, which would be November 7th, would be the jury instructions. The prosecution basically provides the essential elements to instructions and all of the other standard instructions. But if there was going to be a statement of the case instruction from the defense, and I've said this probably a number of times to each of you, just make sure it's not as much factual based as just an allegation based. So if you're going to argue the defendant did not commit the offense because he wasn't there or because of self-defense or whatever it might be, that it would be that, but not a lengthy statement of the case from either side.
Yes.
But those would be due November 7th. And in Microsoft Word, if you're going to submit them so that I can make changes as necessary. I don't believe there's anything else that I need to address, but I'll first turn to you, Ms. Deline. Anything that you think we need to discuss?
No, I don't think so. And Mr. Mustafa, I'll see you at the courthouse on November 4th at 1 o'clock. You have that written down, right?
Yes, but I was wondering about the court date. When do I need to come back?
The trial date is November 14th, so you'll be meeting on the 4th, and we could print you out a new setting notice if you wanted that to have. Would you like to have that?
Yes, please.
Okay,
And
so
if-
Kathy can
Can
print
I
that.
also ask, just because I know that Mr. Mustafa doesn't use phones or email, could somebody write that November 4th meeting at 1 o'clock down for him on that notice too? That would be great.
And did you have a pen handy there? We can, Mr. Mustafa, and if not, we can just have Catherine write that down for you.
I have it here.
Okay, you've got it written down?
Yes.
Okay, so he's got it written down. It looks like that you're on the right track there. And so we'll print that out for you. I would like to have all of the parties here at 8 a.m. on November 14th, so that if there are any issues that come up that need to be addressed prior to getting us started with the trial, we can do that. Anything else from either side?
No, Your Honor.
Okay, I thank you all for being here, and we will see you on November 14th.
Thank you.
Ashley.
And the meeting with Ashley was on November 1st?
4th.
November 4th at 1 p.m.?
All right, we're going to finish up here. Thank you everybody for watching. I'm going to keep up with that trial. I want to see how he goes. We're going to go over to a court addict, which should be starting in the next minute or two. Remember, everybody, Linus is wanting to go to Houston. She needs your money to go. Go and donate to her GoFundMe. She really appreciates it. It means a lot to her. All that other stuff I'm supposed to say about it. All right, but we're going to jump over to the court addict. Thank you, everybody, and we'll see y'all tomorrow.